But the idea is that there are social facts contained in those clauses that perhaps the drafters of the 14th Amendment did not perfectly understand. And that means that we could fill in those misunderstandings now. So they didn't understand the nature of race and segregation back then, and now we can correct those errors. Of course, one of the problems with doing originalism this way is that it opens up a lot of possibilities, including things like same-sex marriage. Right? They also didn't understand the nature of human sexuality, you could say, or the nature of marriage. So why is same-sex marriage not also part of equal protection or privileged disobedience? And in fact, many originalists have proceeded to make that argument since Obergefell.
Join the best in the movement. It's Conservative Conversations with ISI, educating for liberty since 1953.
Welcome back. You're listening to Conservative Conversations with Tom Sarruf. I'm joined today by Dr. Jesse Merriam, who teaches courses in constitutional law, legal theory, and legal reasoning at Patrick Henry College. Prior to joining the faculty at Patrick Henry, he served for 6 years as an assistant professor of political science and the pre-law advisor at Loyola University, Maryland, as well as an appellate litigator at a D.C. constitutional law firm, and as a research associate at the Pew Research Center's Forum on Religion and Public Life. Dr. Merriam lives in an 1840s stone farmhouse in Frederick County, Maryland, with his wife and 4 children. When he's not teaching and writing about constitutional law, he enjoys spending time with his family, lifting weights, and developing the family homestead. And he's joining me today to talk about his recent writing on the diversity regime and the anti-racist Constitution. So, Dr. Merriam, thanks for joining me.
Thanks. And just one slight correction. We now have 5 children. Our 5th child, Genevieve, was born in August.
Oh, amazing. Congratulations. Got to update that on the website, yeah.
Yeah, I do, yeah.
Well, before we begin our conversation, I'd like to thank our listener for listening to Conservative Conversations. This podcast is a production of the Intercollegiate Studies Institute, and our mission is educating for liberty. If you'd like to help us fulfill our mission, be sure to rate and review this podcast on Apple Podcasts to help us reach more listeners like yourself. So, Professor, I came across this recent provocations essay that you wrote for the Claremont Institute's Center for the American Way of Life on how we got our anti-racist Constitution. And when I read it, my eyes lit up. I just thought, wow, this is really excellent stuff. I love the way it sort of mixed constitutional and statutory interpretation, political theory, with practical politics. So let me just start by asking you to run through the basic argument or what you were thinking in the essay, and then we'll dive deeper from there.
Okay, so let's actually start with the latter part of that question, how I started thinking about the essay. And then we'll go through the structure of the essay and what the basic argument is. But in terms of how I came to this subject, it's a pretty long journey. I've been teaching constitutional law and theory for a reasonably long time now. I taught at Loyola for 6 years. I taught briefly at Hopkins while I was getting my PhD, at NYU, at University of Maryland Law School, and now I've been at PhD. I'm entering my 4th year. And each year, when you're teaching constitutional law and you're thinking about it critically, as a scholar, I've just started to really wonder, why does the Supreme Court interpret the Constitution the way that it does, in a way I'm referring to that is so obviously inconsistent with both the text and the history? What leads the court to go so wildly astray from, a Constitution that gives, for example, Congress very limited and enumerated powers in Article 1, a Constitution that spells out pretty clearly what the individual rights will be under the Bill of Rights and the 14th Amendment. And over the years, I've just started to think more critically about how we got the regime that we currently have. And I'm constantly going back to the Civil Rights Revolution, not necessarily as what got the ball rolling. You could certainly look to the New Deal and a lot of those decisions as a critical part of how the Civil Rights Revolution worked. But those Supreme Court cases, and particularly Brown, created a new constitutional order. So what I'm getting at really in the article is what constitutional scholars call a canonization of Brown. Canonization refers to when a Supreme Court decision, not a constitutional provision, but a decision, takes on the role of organizing the system so that, for example, any constitutional interpretation, any provision has to be rendered consistent with that decision. so that when we have confirmation hearings, the first question or one of the big questions is usually, how do you reconcile this constitutional interpretation or this decision with Brown? So that the system is really operating around Brown. And there's not much controversy as a descriptive matter that this is how our constitutional system works. Scholars of various stripes, political stripes, liberal and conservative alike, agree that Brown is the core of the system. What I'm interested in, not whether Brown is the core of the system, everyone knows that's the case, but how it happened. There's some disagreement on that. And then more importantly, what that created. And that's really the structure of the article. The first half deals with how canonization works, particularly as applied to Brown. How do you get a decision in 1954 that essentially takes over an entire system so that everything has to revolve around that? And the second part of the essay is on what follows from that. What are the consequences of canonizing a decision dealing with education, race relations, and diversity?
Let me jump right in and ask you how canonization works, or how Brown did become canonized, because it sounds like we canonize saints. So it's your elevate. It's I guess sacralizing the decision, and I guess that's how you organize the regime around that. It's the core organizing principle. So what is canonization as in terms of constitutional law and jurisprudence?
Yeah, that's a great question. That was a question that came up very early on in the project when I started talking to people about it who are outside of constitutional law and theory. They were puzzled by this term canonization because we often think about it in a religious context. And to canonize a saint is very different from canonizing a decision, because when we're talking about canonization in a religious context, it is not working prescriptively to change something, but rather to recognize something, to recognize the significance of a religious figure in relation to a faith. But when it comes to canonizing a Supreme Court decision, we're talking about something that actually changes the system. So it's not something that preserves, but rather something that transforms. And a few scholars have written about the canonization process. And I think probably the most significant figure here is Bruce Ackerman, who's written three pretty significant books on how various periods in constitutional history have transformed our constitutional system. And he focuses on Reconstruction as a period, the New Deal as a period, and the Civil Rights Revolution as a period. And his theory is pretty similar to mine. I certainly draw from his work, but I do depart in some ways. He focuses more on what I call the construction phase, whereas I identified three particular phases, which I'll go through very quickly. I talk about construction as when the decision is debated. So if you look at this in the context of Brown, between roughly 1954 and 1968, there's a construction. What does this decision mean? Because, of course, the decision itself is rather vague. It's not even clear that Brown is going to overrule Plessy. So you have a period of roughly 14, 15 years where it's unclear, what this is going to mean outside of, the particular Southern schools that are racially segregated. By the time of the Nixon election in 1968, it's pretty clear what this Brown legacy means. And next is what I call the submission phase, where the people who were opposing the construction, this new innovation, start to have to accept the change. And what you find is that a lot of the critics before 1968 all of a sudden start saying, well, okay, you got your change. We're going to submit to it. We're going to stop criticizing it, but that's enough, right? We don't want any more. And that lasts really from roughly 1968 to maybe the late 1980s, early 1990s. And the pivotal point I identify in the article of terminating the submission phase is really the confirmation or failed confirmation of Robert Bork to the Supreme Court. Because so much of the focus in that confirmation was on his originalism as applied to the 14th Amendment. And although he did submit to Brown, this was during the submission era, it was sufficiently critical, his commentary was sufficiently critical of things related to Brown, that he eventually was not confirmed by the Senate. And what this meant was that all legal conservatives from now on, including those who adhered to originalism, would have to start to come up with a way of reconciling Brown with originalism. Whereas between 1968 and this period, you had to submit to Brown as a decision, but you didn't have to organize everything around Brown, right? You could just say, we're not going to focus on Brown. We don't need to accommodate it through originalism. And you could see this, for example, in Raoul Berger's famous book, Government by Judiciary, written in 1977. He's a significant law school professor, really the first significant originalist, makes no effort whatsoever to defend Brown. He says this is inconsistent with the 14th Amendment and then just moves on. But after Bork, that is inconceivable. That's only 10 years later. At that point, all of originalism essentially had to be restructured, had to be reconceptualized to accommodate Brown. And then that opens up what I call the third phase, which is the weaponization phase. And that's when the people who had formerly been associated with the critics start to use it for their own purposes. And you start to see in the 1990s, and much more often in the 21st century, conservatives start to weaponize Brown for purposes of criticizing affirmative action, for saying, well, if Plessy could be overruled, and that was a great thing because of Brown, well, then Roe could be overruled. School vouchers is another great example. In 2002, you start to see a lot of uses of Brown for purposes of defending school vouchers. And once you get the weaponization phase, where both sides see this decision not only as transforming the system and outside criticism, but useful for their own purposes, that's when it gets elevated to what I call a jurisgenerative role, meaning it now has the power to make law. And that's what we have. We have a system whereby Brown is now a basis for making law.
I mean, I remember when I guess it would have been all three of them during the Trump administration, all three Supreme Court nominees, Gorsuch, Kavanaugh, and Barrett, when they would all be asked about Brown. I think they would always refer to it as something like super precedent, something not to be touched. We wouldn't even entertain an overturning or an overruling of Brown. But it sounds like, I guess, from that Berger book that you were talking about, and maybe from some of your commentary, that Brown v. Board and originalism don't go together the way that many originalists today have reconciled themselves to. So I'm wondering if you could talk a little bit more about that.
Yeah, so until the 1990s, it was widely accepted that originalism was inconsistent with Brown. And that's because originalism just worked differently at that point. So originalism, just for those of you who are not aware, is the term that we use to describe examining the text as a historical matter for purposes of interpreting a provision. And the idea is that that historical period confines the meaning, so it's closed, right? So in order to understand, for example, what the 14th Amendment means, we don't just look at the text and say, okay, what does equal protection mean to us? We look at how that term was used at that time in 1868 when it was ratified and what the 39th Congress was doing. Now, before the 1990s, this involved looking at particular drafters, right? So looking at, for example, what the 39th Congress was doing, what those drafters were thinking, what the ratifiers had in mind. Right? So that's the way that originalism worked. And it was something that was not subject to change. So the idea was, if this is what they meant for education, that forecloses the matter. We don't start to think, well, maybe they misunderstood this social fact, and now that we better understand, what separate educational facilities does, what it actually means, that we can now render a different conclusion. The idea before the 1990s was we look at the concrete particular applications, and that's what forecloses the matter. And it was thought critical, perhaps even dispositive, that the very Congress that adopted the 14th Amendment and sent it for ratification was responsible for creating segregated schools in Washington, D.C., because, of course, they controlled Washington, D.C. schools. So that was considered dispositive, or at least highly significant in determining what equal protection meant. And if you read Berger's book, his idea is essentially that equal protection has to do with the enforcement of law. So what that means, for example, is you couldn't have different criminal punishment for white people that raped, black women as opposed to black men who raped white women. You couldn't have a different sort of punishment, different sentences, different sorts of crimes subject to people on the basis of race. But it had nothing to do with what was known then as social equality, which has to do with how people relate in their private affairs. So that was pretty much the consensus, and you find, a lot of works during this period essentially accepting that Brown is inconsistent with the original meaning of the 14th Amendment. A significant work I discuss in the essay is Brent Bozell's, I think, 1966 book, The War and Revolution, in which he focuses on 4 areas of law in which the Warren Court had created this rights revolution. And the first area he discusses is in the area of race and education through Brown v. Board. And this wasn't controversial in 1966. A little bit more controversial when Berger writes his book in 1977, but still not controversial enough that he loses his position. He taught at Berkeley, he taught at Harvard Law School, and it was probably the most significant constitutional law book of the entire decade. So how do we get to, as your question was getting at, to how originalism works today? There were a few important changes. One is a law review article by Professor Michael McConnell, who later became a federal judge and is back to being a law professor now. He wrote a law review article in 1995 that was very important to originalists in terms of accommodating Brown, because what he does in that article is he looks at the 1875 Civil Rights Act, which of course is the precursor to the 1964 Civil Rights Act. And that had originally, not ultimately, but it had originally included a provision applied to schools who said, well, if these radical Republicans who supported this legislation were in favor of integration, now, of course, they dealt only with public accommodations, but there was some consideration as applied to education. Well, then we could apply that to the 1868 39th Congress adoption of the 14th Amendment. And Berger says this is ridiculous. He writes an entire article in response to Michael McConnell, saying, look, it's different time periods. You're dealing with different figures, and you can't just go back to 1868 when you're dealing with a moment from 1875. And of course, the actual legislation, the 1875 Civil Rights Act, did not apply to schools. So he said, if you can't get a majority behind that for mere legislation, how do you expect to get to create a constitutional amendment that would provide for that? Given that a constitutional amendment, of course, is a much more arduous process in requiring the 2/3 of the Congress and 3/4 of the states. But the McConnell article, whatever its merits, nevertheless had a very significant effect on how we think about originalism in the 14th Amendment. And there are a series of changes that happened as a result of McConnell's article. But the basic point is that originalism became much more flexible in terms of how it operates temporally. So that 1875 is not foreclosed in terms of understanding what was going on in 1868, and also much more textually oriented. So the fact that some people have done this through the Privileges or Immunities Clause of the 14th Amendment, some people have sought to do it through the Citizenship Clause, some people have done it through the Equal Protection Clause. But the idea is that there are social facts contained in those clauses that perhaps the drafters of the 14th Amendment did not perfectly understand. And that means that we could fill in those misunderstandings now. So they didn't understand the nature of race and segregation back then, and now we can correct those errors. Of course, one of the problems with doing originalism this way is that it opens up a lot of possibilities, including things like same-sex marriage. Right? They also didn't understand the nature of human sexuality, you could say, or the nature of marriage. So why is same-sex marriage not also part of equal protection or privileged disobedience? And in fact, many originalists have proceeded to make that argument since Obergefell.
Yeah, I mean, I think on that one, I guess he really gets back to a question of nature. So like what you wouldn't change the nature of or the definition of marriage because actually the facts of human sexuality have not changed, just our perceptions of it wrongly. Whereas maybe today we would say that our understanding of race really is better or is different, or even I think is a return to a lot of the understanding of the principles of the founding and a lot of the writings of the founding fathers. I'm reminded of Thomas Jefferson's letter to, I think, Henry Gregoire, where he says it doesn't really matter a lot of the social facts regarding race, about intelligence or criminality or skill. That doesn't matter what their rights are. And so I guess my question is, I guess I think about it more in terms of like Brown overturns Plessy v. Ferguson, the separate but equal doctrine, and public separation on the basis of race. And so overturning that decision would be considered a good thing because it's overturning an unjust regime. So I guess how does Plessy line up or depart from the founders' constitution? How does Plessy fit in here when we're talking about Brown v. Board and originalism, things like that?
Yeah, I mean, I think you could treat it as inconsistent with the 14th Amendment in a lot of different ways. And I think you got at the heart of the matter that we could understand race as something that should be outside of, our notions of citizenship, and perhaps it should extend to education. Of course, the problem with Brown is that it did not, although it said it was limited to education, it created a standard that would seem to lend itself far outside the realm of education. Because the basis for the decision was not what you described, that being an American citizen means that the government may not consider your race, at least in certain areas. What the court said is that feelings of inferiority, that's the famous language, and I think that's the really dangerous language, creates a constitutional violation. So the very fact, and this of course is how the Dahl study was used by Kenneth Clark, that very fact that segregation, separate institutions, created feelings of inferiority became the basis for a constitutional remedy. That meant that the court had to do something. And what that, of course, means is that private discrimination exercised through the freedom of association would warrant judicial intervention. So just to be clear, my point of the essay, and I know that a lot of people will want to misinterpret it this way, is not to criticize Brown in any way whatsoever. I don't go out of my way to defend Brown because that's not my project. What I'm interested in is what Brown created, more specifically, what the canonization of Brown created. So it's not Brown as such, it's the canonization that made two things the moral axes around which our system operates. There's the moral evil that Brown pronounces, which is that feelings of inferiority give rise to a constitutional injustice. And that means that discrimination, all of a sudden, privately expressed discrimination, becomes our greatest constitutional evil that we must eradicate. And the remedy for this that the court ends up providing during that construction phase I described between 1954 and 1968 is that diversity, meaning forced integration, will become the way of dealing with that feeling of inferiority, which means that diversity must become our greatest constitutional good. And these two axes, right, where diversity is our greatest good and discrimination is our greatest evil, structure now how constitutional discourse operates. And that's really where my interest lies. What happens to a system when it's no longer structured around things like self-governance or natural rights, but all of a sudden the entire system is structured, I should say, around the good of diversity and the evil of discrimination.
Gotcha. Yeah, on the diversity point, especially with affirmative action, which I think we can turn to that one a little bit later. But, to anyone who's been paying attention in America recently, diversity is the greatest good. It should be sort of fairly obvious with all the various DEI programs. I think Amazon's now giving $10,000 to Black employees. You have the way that BLM rioters in 2020 were funded and bailed out by the vice presidential candidate's bail fund. Also, how the media runs cover for racial differences in crime, things like that. Critical race theory and anti-racist education in schools. I was an education major at Boston College. We learned how to teach according to that, to promote diversity in all ways, all that stuff. I think the other one, I guess the idea of private discrimination would be more controversial, right? Because if we say that discrimination on the basis of race is wrong because it has no bearing on citizenship, or our Constitution is colorblind, then I guess I don't know what my question is. I'm wondering if you could talk a little bit more about how, I guess, what's lost if we say that private discrimination is a constitutional evil, and then I could go on something more specific.
Yeah, so let's talk about the difference, first of all, between public and private discrimination. So Brown, of course, dealt as a formal matter with public discrimination, and that obviously can be reconciled with the 14th Amendment, the way that we discussed, that citizenship, or perhaps through a colorblindness principle through the Equal Protection Clause, or perhaps it's a privilege or immunity of the 14th Amendment that your race may not be considered in various areas. So there are obviously justifications for that. But the problem, just to go back to the Brown decision, is that feelings of inferiority, which may arise through private conduct, become the basis for a constitutional wrong. And your question is, well, if we can agree that discrimination is a bad thing, what's the problem? Right? What's the problem here? Well, the problem here is that while private discrimination may indeed be a bad thing, what you need to do to get rid of it may be an even more serious problem, at least as a constitutional matter. So how do you get rid of private discrimination? Well, one thing that we've done is we've essentially eliminated the state action doctrine. The state action doctrine is the idea that constitutional protections apply only to governmental actors. Why do we have a state action doctrine? Why does the First Amendment begin, Congress shall pass the law? Why don't we create free speech rights against private parties, or religious freedom as applied to private parties, or Second Amendment rights as applied to private parties? The reason is that it's a constitution that limits governmental power. And the idea is that if you want to silence me, or you don't want to be friends with me, or you don't agree with me, or you don't like my faith, you have a right to express that, because that's also part of your freedom. Now, that may make me feel bad, it may make me feel silenced, it may make me feel less free in some way, but that's an interpersonal grievance, and I can deal with that accordingly. All of our constitutional protections, with the exception of course the 13th Amendment, attach only to governmental actors. But once we make feelings of inferiority something of a constitutional significance, well, all of a sudden our constitutional provisions start to apply to private actors. And then you get situations like the Masterpiece Cake case, where you have two gay men who just want a cake baked for their wedding by Jack Phillips. And he very reasonably says, well, I don't want to bake a cake for you because I don't support your same-sex ceremony. You can go get a cake somewhere else. And I believe there was another bakery something like 7 miles away. This wasn't in some rural area in Colorado. They could have gone elsewhere, but they wanted the cake from Jack Phillips. And they wanted that cake because they thought they had a right to it, and they had that mentality that they have a right to exact services from another citizen because of the mentality that has come out of Brown v. Board. This idea that another person's discriminatory preferences somehow amounts to a constitutional violation, and that means that all of a sudden you get a constitutional clash where none existed before the Civil Rights Revolution. So if you were to go back and talk to an American citizen, say before 1960, I would say, and ask, do you think that there's a constitutional clash when Jack Phillips says, I don't want to bake a cake for you? I think you'd find very few people who saw this as a constitutional problem, maybe a moral problem, maybe a social problem, but there's not a constitutional clash. But as a result of the canonization of Brown and the Civil Rights Revolution altogether, the way that just about every media outlet portrayed the Masterpiece Cake case and all of the cases that have come out of it is in terms of a constitutional clash. The right of the same-sex couple to have the cake baked for them, and the right of Jack Phillips to refuse those services. And what a constitutional clash means is that all of a sudden you need a judicial body to adjudicate that clash. Now we need the government to come in and arbitrate this. It needs to manage our affairs. And that's the danger of dissolving the state action doctrine, is that it turns interpersonal conflicts into legal disputes, and in the process expands the number of collision points between citizens, in turn expanding the power of the judiciary to manage those collision points. And that's the situation we have now, where you have a juristocracy that essentially manages our polarization. And I think that intensifies polarization in the process and diminishes freedom.
Okay, I think that makes sense. It sounds like the problem is this idea of psychological equality as a constitutional necessity has, so it pits that as this idea of psychological equality against freedom of association, which would allow or justify as a constitutional matter private discrimination, though not public discrimination for reasons of citizenship with the 14th Amendment. So I think I understand that. Let me pose a different question, or because I guess an analogy would be parents have the right and the freedom to raise their children, educate them in various ways, bring them up in a certain church, raise them according to their beliefs and the lifestyles, habits, and opinions that they want for their children. That's their right, but they don't have a right to do something unreasonable or harmful to the child. And so even though it's not a state action, the state has the right and the duty to step in for the care of the child if the parent is being neglectful or abusive. And that's something that you were seeing now with some of the transgender debate for transgender surgeries and so-called gender-affirming care for children. We're seeing that argument being brought up on both sides. So I wonder, I guess, if it would be properly analogous to say that along the same sort of logic, the state has, I guess, a duty to step in to limit the freedom of association when you're basically using it in an unjust way, discriminating against someone unjustly. And there's always going to be some, I guess, disagreement or some imperfection related to that. But what do you think of that general line of argument?
I totally accept that line of argument and agree with it entirely. But the point of limiting parental rights is that there has to be a threshold. You have to point to something concrete that has been done to that child, and it's a pretty high threshold, right? It's not just that the state disapproves of the way that the parent is raising the child in terms of, well, they let the child watch too much, TV, or there's too much screen time in this household, or they're vegetarian and we think a higher protein intake is important, or there's too much emphasis on sports or academics. We don't permit the state to do that. You have to show a concrete particular injury that's been inflicted on that child because we think that that parental right is so important to society. I think the mistake of the civil rights revolution is not in terms of creating an anti-discrimination norm, which I fully agree with. It's in treating it as bipolar, in that there can be no regulation of discrimination, or it is just categorical, absolute regulation of discrimination. When we could have taken a third way, right? The third way would find that certain types of services, essential services, or discrimination based on animus. These are types of exclusionary restrictions that we could see a very good reason for regulating. But when we just say that any sort of discrimination whatsoever is going to essentially create feelings of inferiority and thus amount to a quasi-constitutional violation, that's essentially like saying, well, if a parent does something that the state doesn't like, well, then the child could be taken away. And I think that's something we would obviously reject in that sphere.
Gotcha. We're starting to come to a close here. So you wrote an article, I guess bringing this into applications, something very pressing or very prescient recently has been the affirmative action cases, the Supreme Court overturning affirmative action. And you wrote an article for the Claremont Review of Books, I guess in the spring before the decision was handed down this past term. And if I recall correctly, you predicted that the court wouldn't be able to overturn affirmative action because it's so bound up within the logic of the diversity regime. And so when I read that, I thought, oh no, here we have this 6-3 majority on the court for conservatives, and we wouldn't be able to overturn what is obviously a racist. And then there's all sorts of analysis on why it actually doesn't even do what it doesn't actually advance, quote unquote, racial equity in any way that it even purports to. So I thought, oh, this is horrible. But then, it turns out the court really did actually overturn affirmative action. So wondering what you make of the rulings in light of your article and how you see things moving forward.
Well, I don't think that the court did overturn affirmative action. So I obviously wrote the article before the Supreme Court decision, but after the oral arguments, and I talk about the oral arguments quite a bit. And if you read the opinion closely, I don't think it comes anywhere close to overruling affirmative action. I don't think affirmative action is going to diminish in any significant extent. I think affirmative action is going to change. I think what the court did essentially is that it changed how affirmative action is practiced. not whether affirmative action is practiced. And I think that's why you have that very important line in the Chief Justice's majority opinion saying that diversity statements are still permitted. And if you look at how affirmative action has worked in states where it has been banned, and it's been banned in 9 states, it still is implemented, but through the back door of personal statements. And what you're going to get, my guess is, probably more personal statements. Diversity statements will become a bigger part of the application process. The diversity statements, my guess is, will be evaluated according to what kind of diversity it's about. So if you have a diversity statement about what it's like to be a white kid in a majority non-white school, it's going to be put in the white pile. Whereas if you have a diversity statement about what it's like to be black in America, well, that's going to go in the diversity pile. And that's essentially how affirmative action works in states that have banned it. There's still affirmative action in California despite the ban. There's still affirmative action in Michigan despite the ban. So I expect there will still be affirmative action throughout the United States despite the Supreme Court's opinion.
So it sounds like, because I remember right after the decision came out, many colleges, my alma mater, Boston College, sent out emails, reaffirming their commitment to diversity and inclusion. So I guess you're saying that the regime is very much still alive and that the battle is going to be, enforcing the opinion about basically making sure there's fairness in admissions when it comes to not taking race into account. But so I guess I was going to ask if you think that this is a strike against the diversity regime as such, but it sounds like you think it's more of a transmutation or a transformation within the conservative majority about how this is going to function.
It is a strike, so the majority certainly took the diversity regime to task in explaining why diversity is a compelling state interest in challenging really the Bakke-Grutter rationale. But one, I don't think that it's sufficient in terms of what the court would have to do, and I think a big signal here is that the court did not overrule Grutter. When a court signals that it's marking a regime change in terms of how it does constitutional law, it overrules the case that stands for that regime. So, for example, Dobbs tells us there's a new abortion regime because it explicitly overrules Roe and Casey. The court could have done that with Bakke and Grutter, declined to do that because it is operating within that regime. So while it certainly criticized Grutter, it did not overrule it, and that's because it's operating within those parameters. And I think diversity will continue to be a very big part of how colleges work. And a big point I made in that essay, the CRB essay, is just looking at the data at issue in that case. And what that data showed is that if Harvard operated without regard to race, meaning it had accepted merely the top 10% of applicants on the basis of academic credentials, meaning the SAT score or the GPA, Harvard would be under 1% black, would be, I think, 0.76% black. Whereas currently it's over 15% black. Anyone who thinks that Harvard, as a result of this decision, is going to go from 15% black to under 1% black, which is what eliminating affirmative action would mean, I don't think has a realistic understanding of how race works in American law and politics. So if you think that it's accomplished getting rid of affirmative action, then next year Harvard will be under 1% black in its admission. And I don't think that's going to happen.
No. You could even, make the argument that with diversity statements or however Harvard's going to re-engineer their admissions process, it could even increase or it could increase for different groups. But that's unfortunately all the time we have today. So Dr. Merriam, thanks for joining me. And if people want to follow more of your work or stay up to date with what you're doing, where should they look for you?
Well, I'm not on Twitter. I was, but I found it just too much of a distraction with all the things going on there. So I write quite a bit at Law and Liberty. I have an article coming out in the Claremont Review of Books in the fall, and I also have a law review article that I'm working on affirmative action and the DEI mandates, and that will be coming out probably in December or January next year.
Excellent. Well, I'll put some of those articles and essays up in the show notes for our listeners to go read. But thanks again, and thank you to our listeners for listening to Conservative Conversations with ISI. If you've enjoyed this episode, be sure to check out more of our work on our website at isi.org/resources to see all that we offer our members, including the Intercollegiate Review, select Modern Age articles, and of course this podcast. Thanks again for listening. Don't forget to rate and review, and we'll see you next time on Conservative Conversations with ISI.